What's up, co-counsels? I'm right on. No, I'm not on time. I'm like 2 minutes late. Anyways, I had to edit my title. So Real Thing says, "Hi, Essa. I'm looking forward to hearing your perspective on Alessi's end of day motion, and I'd like to know what you think Judge Bev's decision will be." What's up, Real Thing? And then she says, "FYI. Tonight I'll be driving when you go live, so I won't be able to engage unless I get home before you log off." All right, sounds good. No problem. No problem. Be safe out there. All right, let me share my screen. Let me share my screen. Today's what? Thursday. Oh, it's Thursday. That's why I'm here. Duh. All right, let us get into it. As far as today's proceedings are concerned, I started I started following from the very beginning, but I did have to get up every once in a while because I'm working. I'm working. Okay. I have a job. There's an attorney out of, I don't remember the state. What state is that? I don't actually remember, but it's been going around the news of some attorney with some social media following and clients, I believe, brought bar complaints against them because I suppose the attorneys just being on social media, not actually doing their jobs. Okay, they're just trying to get that social media back. In any event, let us get into it. So I've probably watched 60% of today's proceedings. Let us get into it though. I caught the tail end of it. I did not watch the very end of today's proceedings because I like an element of surprise. Okay. I know that Alessi filed a motion basically saying that the Commonwealth violated Rule 14 as it relates to a report. I don't remember the expert's name, but I just had to call it quits a little bit because element of surprise. Let's get into it though. Let's get into it.
Injury had to occur in some
This
manner
this is the medical examiner in this case.
other than falling backwards and hitting. In your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Okay.
Could be consistent.
If we could, Mr. Woke, have the laceration.
And here's the thing: we've already told. Oh, I saw this. I did not watch the actual video, but I've mentioned this before. We use Edge at work. We use Edge. So every once in a while, I have to look up something and open a new tab, and I have all these random news stories just popping up. So apparently, the clerk in the Alec murder trial, sure, she's in some legal trouble. Okay, she's in some legal trouble. I did not have time to actually read what she's charged with. I quickly scanned the article, something to do with her book. Did I read the? No, I did not read the article. I was reading the comments. Never mind. Never mind. Yeah, I'll look into that this weekend.
To the
I'm not saying I'm making a video. I'm just gonna I'm gonna look into it. I'm just gonna read about it.
notes.
What's up, Allie? What's up, Brooklyn?
Hold off on a moment.
Yeah, I started at this point because the juicy part is over here. Okay, we're trying to get into Alessi's motion. Oh, and Allie, I don't know if Brooklyn tuned in for that day. Allie, I have made a commitment. Next week, I will be going live in the morning, but it will only be for an hour, and it will be to cover the Diddy case because there's a lot going on during the week or during my work hours. I really have Karen Reed in the background while I'm working, and then during the weekend, I'm gonna have enough time to actually read up on what's going on with Diddy. So I will be doing Diddy videos. It will be from 7 to 8 a.m. Eastern time. I work 5 minutes away, so I get to work on time. Yeah, it will be from 7 to 8. So I'll commit to initially I was going to do Monday and Friday, but there's just too much content out there. So I will do Monday, Tuesday, Wednesday, and Friday. Okay, we'll test it out for 1 week. If it's too much for me, then I'll revert back to just the Monday and the Friday. But that's I'm just letting you guys know in advance. All right, come on.
Your Honor, Mr. Brennan has agreed to stipulate this going.
Okay, so like we can mark it. 166. Oh, thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr.
She actually looks much older on here.
Will publish.
Yes.
Thank you.
Yeah, because again, usually I'm on my not usually. I'm always on my phone. I'm always on my phone. Hold on, little girl. There you go. I'm always is my mic still connected? Yeah. I'm always on my phone at work when I'm watching this. So I don't usually I need to go back to yesterday's. It's probably not going to be on live. Yesterday's proceedings. As far as clip, was it 19 and 20 that Brennan played? I need to look at that. I need a close up because I could not really hear when I was at work because my volume's usually really low. Anyways, the medical examiner actually looks older as opposed to, looking at her on my screen, my phone.
Dr. Scordi-Bello
What's
says
up?
that exhibit.
What's up, Callie girl? You need to go to sleep. I know you're working, but hopefully you're at a point where you can go to sleep.
Fairly and accurately depict the laceration to the nose.
All right,
of,
thanks, Allie.
Mr. O'Keefe.
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape.
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
Down.
You can take that down, Mr.
Okay,
Wolf.
let's go back. This portion I don't believe I listened to. Let me just go back.
Backwards and hitting the back of their head, could it?
Not by a single event, no.
Okay, so that pretty much would exclude the possibility of John O'Keefe merely just getting out of Karen Reed's vehicle and, falling. So it's one of two possibilities. Either the dog or or Karen Reed hit him allegedly with her vehicle. So it's one of the two. So that excludes a third theory of the possibility that, he just got out of the vehicle, he tripped, fell, and that was it.
You can take that down, Mr. Wolf. On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
Okay.
With your Honor's permission, I would like to Mr. Brennan.
All right, come on, Alessi.
Your Honor, Mr. Brennan has agreed to stipulate into evidence these two photographs. May I please have them marked as next evidence?
All right, friend. Okay, so Brooklyn says that no, he could have gotten hit in the house too. Whether it's in the house or outside, to me, it makes no difference. But to me, what I got from Dr. What's her name? Scortibello. What I got from that response, where she's basically saying that the marks on John O'Keefe's arms could not have been the result of him merely falling. It's just it excludes a third theory. So whether Chloe's involved and it happened in the house or on the lawn, it makes no difference to me. In Brooklyn, have you been keeping up with Diddy or no?
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing if I may, Dr. Scortibello. I'm going to leave
And these are allegations. I was not there. I don't live in Canton,
these
okay?
with you, but I'm also going to waive the court's permission to have them published.
Okay.
Whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you.
What's this down here? Is that their sponsorship? Their sponsor, rather.
With regard to what is on the screen, am I correct that you noted these injuries these wounds to Mr. O'Keefe in your autopsy report?
Yes,
And am I correct that you noted that there was a pattern to those wounds?
correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
So I suppose it's inconclusive. On the fridge, Zeta. Thank you.
Are those injuries consistent with a dog
What happened to the presumption of innocence? What happened to the presumption of innocence?
bite?
What's the question?
With a dog bite?
Based on our answer to the last question, ask something else.
What did Canoni say?
Based on our answer to the last question, ask something
Oh, I
else.
see.
I'm sorry, couldn't hear you.
Ask another question, sustained.
And here's the one aspect. I think my experience with cases overall have helped me thus far. The one part that that probably would have helped with this case is if I did dog bite case. I'm not going to do dog bite cases, but if I did dog bite cases, maybe I'd have an opinion as to whether these could possibly be anything is possible. Whether these wounds could be consistent with a dog bite or something else.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen?
I don't know though. I don't know that all these wounds are consistent.
Okay.
So can you answer that, doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you. Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So Were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital.
What's up, Benji?
And was packaged, and I believe
Benji, I was just saying earlier that I have committed to next week. So next week I'll come up here in the morning from 7 to 8 a.m. But that's only going to be on Monday, Tuesday, Wednesday, and Friday. I'll give it a trial for 1 week, and if it's too much for me, then I'll cut the days down to probably a Monday and a Friday. I hope you had a good day, my dear.
Submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No,
Alyssa, can you use a mic, please?
Hoodie didn't make its way to you?
no,
Mr. O'Keefe, a t-shirt or a hoodie didn't make its way to you?
no.
Oh. Getting distracted. Look here. All right. A minor testified yesterday, and that's the distinction. I got distracted, but I saw Vinny out here talking about John O'Keefe's niece testifying. So it's pretty obvious that Brandon and Lolly, two completely different attorneys, two different approaches. And Brandon definitely did the right thing by having the what is this? The minor testify in camera. What I was not clear about was whether the actual courtroom had to be cleared, or was it just that they were not going to live stream it, right? But that is the right call. It is standard protocol for when minors, not even just testifying, oftentimes even when there's a minor in a criminal court, if they are the defendant, oftentimes cameras are not allowed in there. There was a time, I know when I first started out as a prosecutor, I don't remember, it's like 12 years ago or something, I made the mistake of not clearing the courtroom, and the judge ripped into me. It was not, I did not make that mistake ever again. But, Brandon definitely appears to be that's not a fair comparison. I'm not going to finish that thought. I'm not going to say what I was going to say. In any event, and even one of my public defender jobs, there was a time when a minor was charged. I don't remember what he was charged with, but they pretty much cleared the courtroom. Even the attorneys that were not on the case had to leave. And also, I'm nosy, so I wanted to know what the charges were, but we all had to clear. We all left the courtroom, and I had a really nosy paralegal at the time. And, we were both curious as to what was happening in the courtroom. So again, that's just, I'm trying to figure out, as far as yesterday, did they just cut the cameras, or did they clear everybody else out of the courtroom, with the exception of obviously staff and the attorneys and the defendant?
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you had doubts about the manner of death of Mr. O'Keefe, and you consider those
Not
doubts
enough
reasonable?
information.
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Yeah, I understand that, Brooklyn.
Correct.
And manner of death, as you've testified,
All right, Benji.
includes the
Good.
circumstances surrounding death.
All right,
in
thank you.
addition to the medical analysis that you performed. Okay.
I'm sustaining it, asked and answered.
Thank you for answering my questions, Dr. Scordy-Bello.
You're welcome.
All right, thank you, Mr. Leslie, Mr. Brennan.
All right, I did not watch Redirect. This is going to be new. Yeah.
Doctor, how many autopsies have you performed in your professional career?
At this point, more than 1,200.
Jesus.
When the person is brought to you, are they usually clothed?
It depends on the circumstances. If a person comes directly from their residence, they may or may not be clothed. If the person comes from a hospital where they went first for treatment, many times.
Yeah, so this testimony from Dr. Scortibello regarding the inconclusive manner of death, that's problematic for the Commonwealth. That is really, really problematic. And that's even if we compare it in the context of the Colin Griffith case. In that Colin Griffith case, you know, the medical examiner was pretty, what is this? Stern in the fact that he was like, this is homicide, and they still got an acquittal. So this is very problematic for the
person is
the Commonwealth.
unclothed. They may be wearing a hospital gown, but in most cases, that clothing has already been removed.
Okay.
If that clothing has already been processed, is it common that it would be brought to you for inspection?
Objection, Your Honor.
Sustained is to.
Is clothing that is not accompanying the person's body commonly brought to you for observation?
Objection, Your Honor.
So let's move on.
She said,
Or
let's move.
ask it.
You were asked questions about your opinions relative to spots in the organs of Mr. O'Keefe, and you were asked about part of your statement in the grand jury. When you provide statements, is it important to have the statement in context to understand it?
Yes,
Is it important to have a complete statement rather than just part of a statement?
yes,
And when you were asked the question that counsel asked you, do you remember that grand jury testimony you gave?
I remember it was a long time ago,
Okay.
but I do remember most of it.
Do you remember when he read part of your
Who's
answer?
he?
It was in response to a grand juror's question.
Yes,
And he read part to you, right? I understand your question. And my answer is that I don't know, but given the environment, so if the injuries had been sustained in a different environment where the temperature wasn't that low, then there might have been an alternative explanation for those gastric and pancreatic hemorrhages. Do you remember
Wrong
that?
question.
Objection, Your Honor.
The doctor can answer that.
Do you remember Attorney Alisi read you that part of your statement?
yes,
Do you remember that you had more to that statement that was left off when he confronted you with it?
I'm sure there's more to this.
To complete your statement, you said, but in the whole context, I believe that those are signs of hypothermia and not caused. Do you remember that completion to your statement?
Objection, Your Honor.
Sustained, you
Yeah.
can show her the statement.
Okay.
That is objectionable. And here's the thing about. Never mind. I'll let it go. I'll let it go.
Actually, take a look at part of your grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go through.
Were you asked about your entire answer or just part of it?
Objection, Your Honor.
Sustained.
Did you read the rest of the answer that you weren't given when it was read to you?
Objection, Your Honor.
So this is phrased as refreshing recollection, so follow it appropriately.
Do you now remember there was more to your answer?
Yes,
I don't know. Is
Share
she
with us the
confused or
rest of your
something?
answer?
Without reading
Objection,
it.
Your Honor.
Without reading it,
Right.
turn the paper over, please.
I can take it, Your Honor.
Right, that is
Ask
proper
the
procedure.
appropriate question, Mr. Gordon.
Do you remember the part that was left out?
Objection, Your Honor.
Sustained.
Does it refresh your memory to the rest of your statement to the grand jury?
I'm sorry,
You
what was your
remember?
question?
After looking at this, does it refresh your memory to the rest of your statement you made to the grand jury?
Yes.
And could you share the rest of your statement with the jury, please?
The rest of the statement was that I have to take those findings in the context which was presented to me. So in the case
Having a
of
hard time.
this particular case, those hemorrhages, in the context of a body found in the snow, I believe they were due to hypothermia.
Is your answer more complete in context?
Objection, Your Honor.
Sustained.
You were shown a photograph of two individuals that were in the room at the time of autopsy. Do you remember that photograph?
Okay.
Yes, I do.
And you were asked about certain names.
Correct.
You said that there would be a log identifying names.
It would be a log. Yes.
A log. Do you remember exactly who logged in to that autopsy?
No, I don't remember their names.
May I approach?
Show Mr. Alessi.
This is taking forever. Come on.
As part of the end of the report.
Trying to get to the end.
Take a look at your report. You have it.
Your Honor, if we need sidebar to explain, we just need a moment to take a look.
I can move on and we'll come back to it, Your Honor.
Thank you, Mr. Brennan.
You mentioned that Mr. O'Keefe's body temperature was a little under 81 degrees when he was brought to the hospital.
Yes, that's what the hospital records stated.
And again, a normal body temperature is?
98 degrees.
Okay.
So there was, is it fair to say there was over an 18-degree drop in his body temperature?
Correct.
You shared with us that you generally understood it was a blizzard and cold outside. Do you have any experience on how rapidly a body temperature will drop outside?
The body temperature.
Yes.
Objection, Your Honor. Still.
No, it's within the scope. Let's see if she's got the basis.
Are you okay?
The rate that the body loses heat depends on a number of factors. Depends on conditions, weather conditions. It depends on the original temperature of the body, and the higher the gradient between the body temperature and the environmental temperature, the faster the drop will occur.
I don't know that
You were asked if there's any
question,
signs of
but-
frostbite. There was no type of freezer burns or anything on Mr. O'Keefe's body, was there?
Objection, Your Honor.
Sustained.
Was there any type of,
I mean, it's leading, but I don't know. Brandon does not write out his questions, which I suppose makes sense considering that this is a lengthy trial and you kind of have to be on your feet. But I'd like to know the response to that.
burns on his body that would suggest that he was put in some type of machine or environment where there was
Machine.
cooling, mechanical cooling?
Objection, Your Honor.
Sustained.
Yeah,
Sustained.
that's some point, but it's the form that's improper.
And move on, Mr. Brennan.
You were shown a photograph, a chalk that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
Okay.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you
I'd
given?
hate to be cross-examined.
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
May I approach?
Yes.
Showing you a document. Do you recognize that document?
Yes.
What is it?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
What is Dr. Bello far-sighted?
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, all right?
Okay.
And what's another document?
Let us mark it.
Oh, sorry, can you hand me that back?
Yeah.
QQ for identification.
Thank you. May I approach her on?
Yes.
Second document, was that another document in your file?
Yes.
And is that another report that you considered?
Yes.
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Exhibit RR for identification.
May I approach again?
Yes.
I'm going to go back to the questions I asked you about logging in and refreshing your memory.
Mhm.
I'm going to hand you a document. I'm not going to ask you to read it aloud. I'm just going to ask you to look at it.
Read it aloud. How do you refresh?
Does it refresh your memory on people who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
Okay.
Are you part of the criminal investigation team?
No, I am not.
Okay. That's a
Did you
good
go
question.
to the scene and evaluate any evidence?
That's a good question.
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Yes.
You would ever, let me ask you.
Okay, so the reason why those are good questions is because they clear up for the jury in the sense that the testimony that Alessi may have elicited that a lay individual would have considered damaging in the sense that, oh, you didn't, consider whether these, they're not lacerations. She says that they're abrasions, whether these abrasions were caused by a vehicle or glass or plastic. That is more of an investigative role, and it's not necessarily what a medical examiner would do. So the questions or the responses cleared up for the jurors.
You submitted the death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered at the time you wrote your death certificate or filed your death certificate. Were you informed or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant
I'm going to allow
Is that an
it.
that the
objection?
defendant said, "I hit him, I hit him, I hit him." Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Okay.
Were you aware that there was another first
I
responder?
think that is problematic. The I hit him is, or at least in this context, in the context of the medical examiner, it is problematic for the Commonwealth because even with that information, the medical examiner could not reach a conclusion that the manner of death in this case is homicide. So that's problematic for the Commonwealth.
By the name of McLaughlin, who provided information that the defendant said, "I hit him, I hit him, I hit him, I hit him."
Yes.
Were you aware of statements made by the defendant? Well,
All right, hit the like button, you
to
guys.
Mr. McCabe, that she said, "May have I hit him? Did I hit him?"
Objection, Your Honor, may we approach, please, briefly?
Okay.
Okay, what are they approaching on? All right, what's going on in the courtroom? There's whispering. I don't see Peggy O'Keefe. Was she in court today? I was actually not focused on the gallery. All right.
So jurors, I want to let you know that like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so that as it goes to Dr. Scordivello's knowledge and state of mind at the time of her report.
Thank you. At the time of your death
All right, so
certificate
Real Thing
filed,
says,
were you informed that a Jennifer McCabe
Real Thing said she's not home yet, but she wants to let me know. Alessi and Brendan argue back and forth after the jury leaves for the day. Yeah, I watched part of that. I watched part of that, and we are going to get into it. Not everything, because again, I like the element of surprise. Okay, she says, BRB, I have to drive some more. Don't fret, okay? You get home safely.
had reported that the defendant said,
Yeah, Real Thing, that's why I started this closer to the end. I probably would have picked another aspect of today's proceedings, but that's why I started closer to the end so we can actually just have a smooth segue into the last or the end of day motion.
"Did I hit him, or could I have hit him multiple times?"
Objection, Your Honor.
I'm going to allow it.
I don't believe I knew about Miss McCabe.
Did you learn that Ms. McCabe reported later that the defendant, while speaking to first responders, reported that she had hit him? Did you know that?
I was aware of that information later on.
Were you aware of the investigation regarding alcohol consumption?
Yes.
Were you aware
On whose part?
that the police or Massachusetts State Police
I guess the decedent. That makes sense.
spoke to other witnesses about their observations that night?
About their,
Their observations?
yes.
Were you aware of an interview by Trooper Buchanan with firefighter Daniel Whitley on February 7, 2022?
I don't remember.
Were you aware that Mr. Whitley told the police that the defendant had expressed that she had gotten into an argument with the defendant that night?
That was part of the information I was given, yes.
Were
Okay.
you aware of a report from first responder Anthony Flamate about statements made by the defendant to him?
I don't recall that particular first responder, no.
Were you aware of statements provided by Kerry Roberts to the police that the defendant had called her, citing Kerry, John is dead?
I
Yeah,
don't, that's still off to me though. They'll be part of my first series of Karen Reed conspiracies. I hope to have them out by Sunday, but that is just I don't know. That is incredibly off. That's off to me. I mean, that not that it's enough, not that it's enough for the Commonwealth to meet its burden, but that is very suspect.
I was given that information,
And the questions of did I hit him, were you aware of that?
yes.
Were you aware of information that troopers had an opportunity to go and speak to the defendant?
Yes,
Were you aware of the statements that she made to the troopers?
not in detail.
Were you aware that when they spoke to her on January 29th, she informed that she had a broken taillight on her vehicle but did not know how it happened?
Objection, Your Honor.
I'll allow that.
Yes, I was provided with that information.
Were you provided the information that she had never observed John enter the residence?
I believe that was part of the original information, yes.
I mean, the testimony that Karen Reed did not observe John O'Keefe enter the Alberts home, sure enough, it could mean one thing for the Commonwealth. But in the context of Dr. Scorty Ballow's testimony, it does not help the Commonwealth in the sense that despite all this information that she was aware of, that did not move her towards making a determination that the manner of death in this case is homicide. So, I mean, I do understand why Brennan's asking the questions, but it still does not bring the Commonwealth closer to meeting their burden.
Were you aware that she informed relative to the broken right taillight she didn't know how it happened?
Yes, I was.
Were you aware that members of the Massachusetts State Police obtained John O'Keefe's phone and did a forensic data analysis on it?
I was not aware of that until much, much later.
After you filed your report?
Correct.
Were you aware of location data that was obtained from John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of healthcare data on John O'Keefe's phone before you filed the death certificate?
No, I was not.
Were you aware of battery temperature data on Mr. O'Keefe's iPhone
These are good
before you filed
questions.
your death certificate?
No, I was not.
Were you aware of voice messages
Yeah,
left
these
on
are good questions in the voice messages. Hold on, parenting.
John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you aware of text messages between the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets before you filed your death certificate?
No, I was not.
All right, let's quickly go back. Let's just go back.
Before you filed of battery temperature data on Mr. O'Keefe's iPhone before you filed your death certificate?
No, I was not.
This
Were
is
you
very
aware
direct.
of voice messages left on John O'Keefe's phone from the defendant before you filed your death certificate?
No, I was not.
Were you
Okay,
aware of
so these are good questions in the context that, I guess from a prosecution perspective, the doubt that the defendant or the defense is trying to sow into Dr. Scortibello's testimony, it pretty much shows that her examination and the report, independent of some of what is this, some of the doubt that the defense is trying to sow into the prosecution's case.
text messages
That's why I
between
like these questions.
the defendant and John O'Keefe before you filed your death certificate?
No.
Were you aware of statements from the defendant to various media outlets?
This is also Brennan's opportunity to remind the jury, or at least to focus the jury on what he wants them to focus on. For instance, the interviews and the conversations or communications between Karen Reed and John O'Keefe right before he passed.
Before you filed your death certificate?
No, I was not.
Did anybody ever come to you after you filed your death certificate and ask you
What
to
do you mean,
change
Brooklyn?
it?
No.
Did anybody ever provide you any of this?
What was that? I missed that.
Did anybody ever come to you after you filed your death certificate and ask you to change it?
Okay.
No.
Good question.
Did anybody ever provide you any of this additional information
That is a
you
good
weren't
question.
aware of at the time, ask you to evaluate it, and then reconsider your finding?
No.
That is a good question.
You were asked some questions about impact injuries. In your experience, are most pedestrian collisions where there's injuries to the lower legs, either frontal or rear impacts?
Objection, Your Honor.
I'll allow that because I'll allow that.
Most pedestrian fatalities that we see are with impact with the front of the vehicle.
So I suppose the purpose of this is to show, I suppose, that Dr. Scortibello would not have or does not have that, or maybe she cannot speak to injuries caused by rear impact. I suppose that's why he's bringing this in.
When you gave the perspective that
Yeah,
you
let's
look
go back to the question before that.
or rear collisions, in your experience, about impact injuries.
Okay. Yeah, I think that's why he's bringing, or that's why he's eliciting that testimony.
In your experience,
We can fast forward a little
I'll
bit.
allow that.
Most pedestrian fatalities of the vehicle.
when you gave the perspective that you looked for impact injuries, was that with consideration of your experience that most collisions are frontal impact injuries?
Most collisions involve frontal impact, yes.
Yeah, that was not the question.
How about cases where you had an opportunity to observe people who sustained injuries from being clipped? Not hit, but just being clipped. Is your opinion any different in your experience?
Objection, Your Honor.
Sustained in that form.
Okay. How about a side swipe injury? Is that different relative to your expectations to lower extremity injuries?
Objection, Your Honor.
Sustained.
A bruise on the knee, is that consistent with a side swipe impact?
Could be.
Did you do any type of
That is what I do not appreciate about expert witnesses. With expert witnesses, anything and everything is a possibility. So, so you don't. I mean, some testimony can definitely clear up. Can clear up some issues in a case, but otherwise, whether they are questioned by the prosecution or the defense, anything and everything is a possibility.
Biomechanical analysis of any
Never
alleged
solid
collision in this
yes,
case?
no.
No, I did not.
Were you asked to?
I'm not qualified to do that.
And so when you talk about injuries from a collision, are you in part speculating about what could happen to somebody?
Objection, Your Honor.
Sustained in that point.
Are you giving a direct opinion in this case about how the injuries were caused?
Objection, Your Honor.
Sustained.
You were asked questions about a nose laceration,
Yes,
and you offered that was not consistent with falling backwards on the head alone.
correct,
You were asked if that was consistent with a punch.
correct.
Objection, Your Honor.
That's not the testimony. That's your objection. Mr.
That is, Your Honor. There's not a question.
Did you provide an opinion that it could be consistent with a punch?
I did provide that opinion.
Could it be consistent with broken glass?
It's possible.
Could it be consistent with sharp shards from broken plastic?
Possible.
Again, this is why I don't like expert testimony, because everything and anything is possible.
Could it be consistent with first aid?
I'm sorry, what was
Could
it?
it be consistent with first aid treatment?
Anything is possible.
Do you have any firsthand?
Yeah, but I mean,
knowledge?
during cross-examination, she was asked questions that extended beyond pathology and cause of death, and that's why the redirect is proper.
Knowledge of how the laceration on the nose happened.
I do not have firsthand knowledge.
Did you know at the time you filed your death certificate that there was plastic pieces of taillight found near Mr. O'Keefe's body around 5:45 p.m. on January 29, 2022?
I do believe some of that information was communicated to us, yes.
Thank you.
All right, Mr. Lessie.
Okay. We ended on a good note. Let's get into recross. How much more time do we have? We should be good on time, I suppose. We might have to fast forward because dang, how long were they up there for? Oh, that's actually much longer than I had realized. All right, we'll listen to this and then I think this is like what, 10 minutes?
Thank you, Your Honor. Dr. Scorti-Bello, this Attorney Brennan just asked you questions about alcohol consumption.
All right, let's fast forward a little bit because I don't want to be up here late. Let's get to the very end of the recross.
Included the words, did I hit him? Could I hit him? Do you recall those questions?
I do.
And isn't it correct that you had that information?
Unless he's so dramatic. He is so dramatic. Let's go back. Okay.
And isn't it correct
Okay.
that you
Correct.
had that information before you issued your final findings in
Right.
this matter in April of 2022?
Yes, I did.
So
He's so dramatic.
even though you had all that information,
Use the mic, bro.
you still
Right.
were unable to conclude the manner of death of Mr. O'Keefe, correct?
Right.
Correct.
Yeah, and as I said, that's what's problematic for the Commonwealth in this case. It's not so much about the Alberts, the dog, this and that. It's really the fact that the medical examiner, the individual that is tasked with determining an individual's um, cause and manner of death, does not have an answer. That's what's problematic with this case.
Shorty Bello?
All right,
Was that it?
Doctor, you are all set.
Thank you, Your
very
Honor.
much. I'm going to see Counsel at sidebar.
Ms. Portobello gets ready for her next testimony, I suppose. Where's Peggy? All right, come on.
All right, so yours, that is.
Okay. All right, let's get into it. I had not realized that the defense and prosecution were edited for a little bit. I thought it was like 10 minutes or something.
I would like to raise with Your Honor.
Okay.
I'll hear you, Mr. Lessie.
Thank you, Your Honor. The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welter, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes. That
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until May, not established, they had stated in the reports of
Let me put my phone down. Hold on.
has established in reports right up until May, not established, they had stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162.2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where this statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. No, I'm just going to get it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2.
Hold on, I got
And
distracted.
in that
What?
report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162.2 is further back in time, and it is past 12/31/43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12/32/16. And Your Honor may recall that the seconds, literally seconds matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analysis. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 12/31/38 to 12/31/43. As of May 11th, we received information that has changed that. Now, Your Honor, that is a Rule 14 violation among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want
Oh,
to
is
do, Your
Brennan
Honor, is
writing? Oh, he's writing his response, I suppose.
look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis. And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available
Come on, Alessia, I'm
years ago.
tired.
So to me, Your
Get to
Honor,
the point.
that basis can't be a proper basis, at particularly
All right,
this stage where we
Brooklyn.
are
Good night,
approaching
Callie.
the end of the trial.
Yeah, I suppose I understand why Peggy would not like to be present for that. That does make a lot of sense.
Just literally days
Difficult for
before
her.
the testimony of Aperture, and we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here. Our first request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an
He's so dramatic. He is so dramatic. I like listening to Alessi, but he is definitely hyperbolic.
example of an ambush, this is it.
And
And so
listen, fair enough. Well, prosecution is a prosecution. They bear the burden of proof. But I think I suppose this is why it's Alessi that's making this motion as opposed to Jackson, because he's a very problematic individual. But what this is sounding like to me, it sounds as if the defense is of the opinion that they can skate the rules because they represent the defendant and they're not the Commonwealth. and that the Commonwealth should be punished for any and every alleged violation that the defense is claiming, whereas the same rules do not apply to the defense because they represent the defendant. That's what the argument sounds like to me.
So, Your Honor, our request is that Your Honor find a Rule 14
I'd
violation.
really be embarrassed. I would be embarrassed to be bringing this motion as a defense attorney after the bullshit we just pulled regarding our. I would personally be embarrassed.
That Your Honor have the remedy be that the violation, remedy be that this is not allowed, and that the Commonwealth proceed with its, the information of aperture.
Let's think about that for a little bit. Let's think about it. The question that I'm considering right now is whether a judge, not so much Rule 14 violation, but whether a judge such as Canoni can be in a position to tell the Commonwealth or the prosecution how to try its case. That's what I'm considering. That's what's going through my mind right
that
now.
has been extant before the May 8th date of the report. Thank you.
Okay.
All right. Do you have another option if
What
that's
was
not?
Brennan doing this whole
Has
time?
been
Is
the
it
information
scrolling? Hold
of
on.
aperture that has been
Come on.
extant.
What is it looking at?
Commonwealth proceed with its, the information of aperture that has been extant before the May 8th date of the report. Thank you.
Okay.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old report, right?
Right. And Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because two reasons.
Listen. Again, this is an issue that defense created that should not have existed. What I mean by that is right now, excuse me, I know what Brennan's response is going to be, but right now, Canoni is in a tough position where she has to act in a fair manner to the Commonwealth and the defense. So, absent, what's his name again? Alan Jackson's improper conduct. And again, once this case concludes, I am going to be very curious to see what, if anything, happens with Alan Jackson's. Bar license. So will somebody issue a complaint? Because again, we have to consider the possibility of, let's say, for example, this thing ends in another mistrial or if there's an acquittal. I do not, I see a clear path where somebody that is related to John O'Keefe could potentially file a complaint against Alan J. People like to gamble. I don't know why people like to gamble, but that's a path that I could potentially see. In any event, going back to the issue at bar here, under the circumstances where the defense had not created this whole archive issue and the signal messages and the erasure of text messages, had they not created that issue, I think Bev Canoni would have had a much simplified position. A position would have been very easy. You're the prosecution, and this is how you're going to proceed. But now she has a task position of balancing her prior ruling regarding the exclusion of defense expert and these amendments to the report. So that's the issue here. So again, I don't know why the defense did that, but they did what they did, and it's done.
We are the defense, and ARCA is
That's
a
a stupid,
rebuttal.
that is a stupid response because again, your both sides are represented by licensed attorneys, and the attorneys do have a code of conduct, and they certainly have to comply with discovery disclosure deadlines.
To the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right.
have
So-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy
I don't know. Alan Jackson, I don't know.
here is exclusion.
And I don't know if he has a tan or if he's just reading the I don't know what's going on, but this is a mess. He engaged in conduct he had no business.
Rule 14 violation.
And you're not waiving that.
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow.
Okay, so she says continuance for how long? So I suppose what they're trying to do is give what is this? Give the defense experts more time for them to pretty much be able to respond to this new development.
Oh, I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARPA.
All right, so tomorrow morning, let me know that.
Yeah, sir, you need to sit down because this is a mess you created. This could have been very, very easy and simple.
All right,
In Your Honor, I will do that, of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen, I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months.
Okay.
And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to
Dang,
align
how's it
with
almost 10? How much time? Dang. I'm gonna have to be up here much later. I was gonna usually I go to work later on Friday, but I have to go. Oh shoot, I forgot to send the email. I'm gonna have to go in at 7 tomorrow because I'm gonna have to leave during the day.
data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you.
What was the response?
To the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's
All
question.
right, thank you. Mr. Brennan.
Wait, what?
To align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's
All
question.
right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone. If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time given the clocks.
I'm getting distracted. I'm sending emails.
Talk
Hold on.
about the facts are different. Case, including my work on their case and study their case as time goes on. This issue, the relevance of this issue, has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus
Okay.
that runs on a different time than that of an iPhone. If you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga.
All right. So here's the real issue. In order to determine whether this is a Rule 14 violation of Massachusetts criminal procedure, we have to go to the actual rule. Okay. It's kind of lengthy. I don't know that I've time to go through everything right now because I'm already behind schedule. But there's a portion here. Why did I scroll? Hold on. Okay, so I suppose this is in line with what Brandon is saying right now, which is um, the continuing duty to disclose. And it says that if the prosecution team subsequently obtains possession of items or information subject to disclosure under Rule 14b, the prosecutor shall promptly disclose to or notify the defense of its acquisition of such additional items or information in the same manner as required for initial discovery. So we'll have to, I can quickly review this, but the problem is I'm going to have to keep rewinding and you guys are going to get annoyed. This is the defendant. We're not interested in that. Blah, blah. Anticipates the possibility. Blah, 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 blah. Necessary. No, hold on. Let's let him talk.
Expert witness who they've listed as a witness they potentially called. Mr. DeSorga wrote a report, and in the report, he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the texting data, the black box data from the car, has a event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report to see if he was accurate, that the variance means that these times would never align. And that's what he did. He studied the data, he studied the ways, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned from his opinion is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moments when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it. We turned it over on May 8th. There was no delay. It's been a week now. The defense has had
Right. So what Brennan is basically saying is that, he's saying he was surprised to receive it. So it sounds like this is not something that he went out and sought. Let me just go back.
Not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it.
I know Riley is kind of red as well. I don't know what's going on. It might be hot.
On May 8th. There was no delay. It's been a week now. The defense has had this information.
Okay.
And so this is not an attempt to align anything. While it may reconcile or identify that variance more closely, it doesn't change any data whatsoever. And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it's clarified and it is favorable for us. And so we should be able to use it.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data. As I said, this
Said
wasn't
disorder. She said
ambush,
disorder.
isn't something that we sat on. It was in response. Fortunately, we received their expert report, which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
I'm just trying to look
Okay.
at some of the case law.
Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information,
Mhm.
and he has accurately provided information, but he's got the
I
time
like the way these two argue.
completely wrong and the significance respectfully completely wrong. I'm going to hit his four
Respectfully.
categories quickly. He said, he referenced Mr. DeSorbo, who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within this reciprocal discovery deadline.
Okay.
And he provided that report
He is so dramatic. This man is so dramatic.
months ago.
Okay.
So
Why are you
if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May 8th is because Mr. Burgess supposedly is responding to that. That was months ago.
Okay.
The more apt point is, or an even more apt point is, Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for
All
Attorney
right,
Brennan's
let's
argument, however,
quickly wanted to take a look at just some of the case law. Hold on. I guess I'll let him finish. They're not going to finish anytime soon. I'll let them finish, and then we'll touch base on some of this case law.
is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is.
All right. While we're at it, let's just quickly take a look, because again, I was thinking about this issue in the context of what is the other trial that I mean, I talked about it briefly. The case out of Georgia, I bring that case up a lot. The Melody Ferris trial. In that case, while the trial was going on, what was that lady's name? It was a surprise witness, okay? It was a surprise witness. She was in Tennessee at the time. Older lady, I don't remember if her name was Nancy. I know where I got Nancy from. Oh, Martha. I think her name was Martha. Martha somebody. I don't remember the last name. She was related to, I was thinking about this name just the other day. The name starts with an S. She was related to the man that Melody Ferris was having an affair with. The name starts with an S. I don't remember. In any event, so Martha was watching the trial on Core TV or Law and Crime, and that's when she suddenly had the epiphany that I got distracted because I was just thinking about the name right now. In any event, that's when she got the epiphany that Melody Ferris may have gotten a hold of one of the firearms that she has in her home, and that's the firearm that um, supposedly she could have used to kill her husband. Okay, so in that case, it's a random person watching or following the trial sitting in Tennessee, and that individual then reaches out to law enforcement, says, I have information. She was interviewed. Within a few days, she took the stand. In that case, defense obviously opposed her testimony, right? They opposed the testimony, but the court overruled the objection, and Martha Jean or Martha Joe or something, whatever her name was, she got to testify. So in this context, though, if we're looking at Massachusetts and if we're looking at Rule 14 itself, I mean, that's why we have precedent. You have to refer to it. So what I just read here is that basically they have a portion that talks about mandatory discovery for the defendant. This provision lists the items that the prosecution must produce for discovery, with the qualification that the prosecutor's automatic discovery obligation is confined to ascertaining and delivering relevant material it and or its agents already possess or control. So that's the word that's sticking out for me, whether they are already in possession thereof or whether they control it, right? And the reason why I brought up the Melody Ferris trial is because, again, completely different jurisdictions, but oftentimes a lot of these rules are the same. Every once in a while, something might be off, but for the most part, a lot of these rules are the same because um, they're framed or right. Their basis is usually federal law. Okay. Again, the reason why I brought up the Melody Ferris trial is because of that. The two words, or rather, the word already possess or control. Under the Melody Ferris trial, obviously, the prosecution was not in possession or control of Martha Jean's testimony because she was out in Texas and not in Texas, in Tennessee. Nobody had identified her as a potential witness, and she volunteered her services apparently. So, under these circumstances, the amendment, if we have to look at the prosecutor's continuing duty to disclose, can it be argued that Brennan or the prosecution, they were already in possession of the so-called amendment as it relates to the times lining up? I think that is the key issue here. So it goes on to talk about the first paragraph of the subsection limits the Commonwealth's discovery obligation to material in the possession, custody, or control of the prosecutor, persons under its direction or control, or persons who have participated in investigating or evaluating the case, and either retort to the prosecutor's office or have done so in this case. This language inserted in 2004 is not intended to change existing case law, but to reflect it. The language is specifically drawn from Commonwealth v. Day. This is a 1992 decision, also stating that a prosecutor cannot be said to suppress that which is not in his possession or subject to his control. Day, in many cases, since described the prosecutor's duty of disclosure as extending to all discoverable materials existing in its own files and in the files of others who have participated with them in the prosecution. The letter officials are usually police, but may include others assisting in the prosecution. Thus, in Commonwealth v. Martin, this is a 1998 decision, reversed a conviction because the prosecutor failed to turn over evidence he did not know existed, but which was known to the Commonwealth's crime lab because the prosecutor had a duty to inquire concerning the existence of such tests. So, if we go back to Brennan, okay, there was a word I paused. I believe he said that he did not know it existed or something along those lines, or he said he was surprised, something along those lines. So the question that the court really has to assess, for one, they have to assess if it can be said that the prosecution was already in possession of this amendment. I suppose in this case, it could easily be said no. But the other question the court has to consider is whether Aperture, or whatever the firm is, whether that is considered a branch or an extension of the prosecution in the same sense that a police department would be considered to be a branch or an extension of the prosecution. Okay, and then we go on. I lost track here. We go on to Commonwealth v. Bing Xia Liang. I don't know where this name is. Bing Xia Liang. I don't know. It's a 2001 case. Victim witness advocates are part of the prosecution team and are subject to the same discovery rule. Again, we go back to that question of whether Aperture can be considered to be an extension of the prosecution. That's probably what Alessi should have been arguing, as opposed to him saying that the prosecution is subject to rules of criminal procedure, specifically Rule 14, whereas the defense, because they don't bear the burden in this case, they can pretty much skate the rules, because that's the argument he made. Let us go on. Where was I? Okay, Commonwealth v. Gallarelli. This is a 1987 case. It says, it is also clear, however, that the scope of the prosecutor's duty of disclosure does not extend to complainants and independent witnesses who are not agents of the prosecution with regard to some aspect of the case. Again, it's the same consideration. Aperture and Dr. I forgot. No, is it Burgess? I think it's Burgess. Whether he can be considered to be an extension or a branch of the prosecution. And then let's keep going. I need to get my glasses. I just lost track of where I was. Okay. All right, then we go to Commonwealth v. Lampron, 2004 decision. Records of medical and social services providers, including DSS. So apparently those are extensions of the Commonwealth. Commonwealth v. Beal. This is 1999, talks about the complainant. Commonwealth v. Waynes, 1998. Rule 14 does not reach internal affairs division records because the IAD is not part of the prosecution's team. All right. And then it says under A1A, each of the following items must be produced for the defense at or before the pretrial conference, provided it exists. Okay. Provided it exists and is one, relevant to the case, two, within the possession or control of the prosecution or its agents as just defined, and three, not the subject of a motion for protective, there's no protective order here, which stays its production under subdivision A1C. Even before the 2004 revision, the prosecution was required to turn over most of these items in district court and the Boston Municipal Court. And then they gave out the rule, which eliminated trial de novo and mandated broad discovery to the defense. And then it talks about taking out the defendant. That does not apply. So that's where we are. Let's see the rest of this motion.
Almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case.
Okay.
So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first
All right, I thought Burgess was, no?
No, neither, no one from Aperture was.
I knew
Your Honor.
Aperture wasn't. I thought he may have been some. The name just sounded.
Neither
familiar.
Burgess nor Welcher were part
Okay.
of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024.
Okay.
And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time. Mr. Burgess, in his original report months ago, has a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay. So what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
In 60 seconds.
Okay.
Thank you, Your Honor. Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised.
Again, this is what is this? This is a felony case, so it does not, again, it's murder, so that does not really apply. But I was just thinking in terms of discovery violation. Oftentimes, I don't know that you can do it with, I'm trying to think back to my public defender days. I don't know that you can do it with a charge such as murder. But as far as speedy trial is concerned, if, as is the case here, the Commonwealth then goes on to disclose more information, what defense, or at least what public defenders often did, was they would go back and recalculate speedy trial. So if under these circumstances, if Judge Canoni finds that the not even, because it really does not matter whether it's timely or not timely, it's just the disclosure of new evidence that tolls the clock. And under those circumstances, defense attorneys usually, shout out to all public defenders, usually would recalculate the time. And if a lot of time had lapsed between the time when the prosecution said they were busy and when they're disclosing new evidence or new reports or new amendments, if that time goes beyond speedy trial, then you can file a motion for speedy trial violation and get your client off. But I don't know that it would work in this case for Karen Reed because of the charges. And I'm just going back thinking about case law. It's the charges. It's also the grand jury proceedings. Let's move on, because I cannot be here
He got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding fetching reason to not allow it, because they're surprised to get it. And I can lastly say this, Your Honor,
I don't like that argument. What I thought Alessi was going to say is that if the Commonwealth, the folks that actually bear the burden, are surprised by a report or amendment by their own witness, then the defendant is even more surprised, considering that this is not their witness. That, I think that would have been a better argument.
nobody that's more surprised to getting this than the defendant.
Oh, there we go. Okay, so apparently Alessi and I are aligned. So apparently we are aligned and we both think like lawyers.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly, the efforts of the defense were improper.
And that's what I'm saying. God damn it, Alec Jackson is so. It's just so. They have done a lot of dumb stuff in this trial. Dude, you had an almost perfect defense case, perfect defense case, and you just go ahead and decide to give the prosecution some ammunition. That is just the dumbest thing I've ever seen. But that's I'm sorry. I'm really in my feelings because that's gonna keep coming back to bite him. What the hell? What?
We've now received an extraordinary amount of discovery on the most important issue in this case,
That is just so
well
funny.
beyond the discovery deadlines, without any excuse. And the court, understandably, has.
That's what I said. The defense put Kanoni in a position that she otherwise would not have been in.
Overruled government's objection and has stated that it's going to allow the defense to proffer two expert.
So goddamn stupid. You had an almost perfect defense case.
Witnesses in a very
And
complicated
you go ahead and mess it up, engaging in improper conduct, things you had absolutely no business doing.
an issue that is the heart of this case. If you're going to allow them to testify, despite the fact that we have not had adequate time to review and to prepare and to address it. The Commonwealth has the burden of proof.
Benji, my day has been okay. I had a really rough week. I'm tired. I'm really exhausted. I cannot wait for the weekend. I'm gonna reward myself with a beer tomorrow. Yeah, it's been a busy week. It's been a busy week, but I think it's really busy because we have more cases. We have too many active cases and not enough manpower. I think there's going to be a point where a firm might have to hire another paralegal because we're just overworked at this point. We are overworked. I'm probably not even probably, I'm definitely working this weekend. So that's a long way to say I've had a busy week.
The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue.
My mic messed up. I was just asking how your week has been, Benji. And how's your girlfriend? You don't talk about your girlfriend no more. Is she still around? Is she still around? I mean, you don't have to tell me, obviously, but I'm curious. All right, let's see.
Despite the fact that we have not had adequate time to review and to prepare and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information to Dr. Wexler. As you know, he was away. He did not get a report until maybe May 2nd. He did not have a chance to look at it until May 9th. An extraordinary amount of work, effort, and expense has gone into preparing our case for the jury. He is still in the process of reviewing the materials. There are entirely new subject areas within this information, well beyond the simple 4 opinions that they gave at the beginning. There are studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting,
Right.
and then
I'm glad to hear that, Benji.
to address claims may invite
I'm glad to hear that. I think it's rewarding to be in a relationship with somebody that actually cares about you.
defense experts. Not to get into a battle of disparagement, but our expert has
There they
found
go. They're about to disparage each other. Go on, go on, go on. Do your thing.
extraordinary issues in his first reviews of material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses.
Whoop.
That's going to take time. You've heard from the ARPA witnesses themselves. With the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline.
That is the problem. That is like I honestly hope every time that Alan Jackson goes home, he looks at himself in the mirror, and realize what a mess he's created.
Violations. They were given 5 weeks. We did not get the report.
I mean, if he was the defendant, sure enough, go ahead and mess up your own case. But as the attorney, even if he was doing this with his client's permission, I don't know that. I don't even know that that's a justification for an attorney to say that they were just following following their client's orders. But I just that is incredibly stupid.
Until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime soon and have all of this validation and vetting and testing.
So what is it exactly you're proposing?
Right.
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now. So by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. We ask that he be able to continue his review, offer rebuttal opinions on anything that is new and not to encroach on anything that's been previously provided.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess' information material. It will make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
Right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor.
Okay.
I think and I understand that this very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARPA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on
Okay, good, because my pithy conclusion is there should be
She's ready to go
no
home.
prejudice on that.
and I don't think the Commonwealth's even suggesting that. So
we're focusing just on the quote new information bucket. Your Honor, it's very important to understand that what ARPA is doing is in response to the testing of Aperture. ARPA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined
Come on now.
what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, and with Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it. We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided. I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and
No,
then the
that's
question
nice,
was
Benji.
a remedy. So I'm just
I'm truly happy for you. That's good. That's
addressing
good.
the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come
That's
back
what a
and
rebuttal
essentially
witness
have
is.
almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto
She's out
gives
there.
a
She's out there nodding, say, yep, I am being prejudiced. Let's go back. Here, Reedy's out there nodding.
It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double rebuttal, surrebuttal to the defense.
Okay.
I believe, Your Honor,
I'm
the
ready.
final point
That's
is
fine.
if Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's
Okay.
another, and importantly,
Here's a point, though. Anything and everything the prosecutor does or the prosecution does is prejudicial to the defendant. The real test is whether it's unfair prejudice.
burden shifting to the defense.
All right, so I have a question for you, Mr. Lessie. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
Yeah.
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so
Okay.
I appreciate it. All right. Thank you.
My device is about to die.
All right.
All right, let me just say one thing. I wanted to jump into yesterday. Let me see if I can. I don't have my notepad though. But let's quickly go back to Rule 14, okay? So, Rule 14, as it relates to sanctions, I think I just lost. I lost where I was. Hold on. Okay, so when it comes to sanctions, they go on to say that although the court may exercise its general sanction power under subdivision C2 to exclude evidence, it is generally better to grant each party the freedom to present all relevant evidence at trial. Okay. And then it goes on to talk about alibi, blah, 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 blah. Okay, blah, 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 blah. Evidence concerning the defense, lack of criminal responsibility. Okay, all right, there we go. All right, so Real Thing says, hey, everyone, so what do you think Bev's decision will be? So Bev's decision got disconnected. My device is about to die, so if it goes off, I'm not coming back. So be aware of that. As far as Bev Canoni, here's the difficult part about this is really Alan Jackson's conduct. Outside of Alan Jackson, the prosecution would kind of have a difficult time bringing this in. But the real argument or the real consideration is whether aperture can be considered to be an extension of the prosecution. That is the real determination. Okay. If it can be considered to be an extension of the prosecution, it doesn't come in. If Bev Canoni determines that they are independent, then it comes in. Again, what's his name again? When Alessi was talking initially, again, I do not know that a judge can dictate how the prosecution puts its case on, considering that they're the ones that have the burden of proof. I'm really mad. I'm upset with Alan Jackson right now. No, I'm a complete stranger, but I am upset with him because he has made a mess. He has made a mess. I'm gonna go back to yesterday. Hopefully this thing does not die. Yesterday I missed. Girl, you need to go to sleep. You need to iron. You need to do stuff. I'm gonna go back to yesterday. Where's that? No, 6 hours. Oh, never mind. 2 days. I think it's here. I wanted to. I don't have my time. I don't have my legal pad right now, but I wanted to see if I can get to the clips.
Commonwealth would seek to introduce and show the jury is clip 20.
All right.
Commonwealth would seek to introduce and
I
show
could
the
not
jury
hear what you were saying.
is clip 20.
There's any window here that you guys have really been going at it.
I cannot hear what he's saying. All right.
There's any window here
Okay.
that you guys have really been going
That you guys have really been going
at it. This was sort of like a last date element to it. Was that going on? That was
was not breaking. John made it clear to me, I'm never breaking up with you. Not never that we're in this good or bad, but you're the best person I've ever.
Who said what?
That we're in this good or never breaking up with you. That was not breaking. John made it clear to me.
The last innuendo here, that you guys have really been going at it. This was sort of like a last date element to it. Is that going on?
That was not breaking. John made it clear to me, I'm never breaking up with you.
Okay, so she made it clear that she was not going to break up with John O'Keefe. I don't know. Why is the prosecution bringing this in? That she, I don't know, a matter of life or death. Is that why they bring it in?
Not never that
Okay, so instead of just calling it off and breaking up, she'd rather just hit. I don't know, hit him. Is that why the prosecution?
we're in this good or bad, but you're the best person I've ever.
That's a hot mess.
The Commonwealth would ask to show clip 19.
Okay.
What's the
I
question?
don't think. I don't think. I don't see how John would have known about my text with Brian. And I'm not sure.
Ah, ah, this is terrible. Let's go back a little bit. What the hell? What are you people thinking?
I don't think. I don't see how John would have known about my text with Brian. And I'm
Why
not
the hell were you doing all this talking, and why the hell did you have attorneys allowing you to be interviewed?
sure if he knew, he would have reacted very strongly. I think we would have broken up, but I don't think John would have lost it and caused a fight. I didn't feel like John's emotions with me got really strong.
That is just incredibly stupid. That's really dumb. So that undermines the hmm, that undermines the defense theory that John would have gotten into a fight with Higgins. This is just, what on earth? All right, so Real Thing says, how much charge do I have? I have 7%. Real Thing says, outside of your disappointment with Alan Jackson, the Commonwealth expert changing the time of impact mid-trial after reviewing ARCA's May 7th report says a lot. I don't know that it says a lot because, again, there is a continuing duty for the prosecution and the defense to investigate their case. So to me, again, this is from a lay perspective, it probably says a lot. From my perspective, it doesn't say much because what it sounds like, and I don't know that they're changing their theory. Did I read that right? I don't know. I cannot see. In any event, I don't necessarily, that's not how I would characterize it, but I understand why you'd put it that way. All right, folks. Let me call it a night. I need to iron and do a whole bunch of stuff. Um, I definitely enjoyed today's court session. I thought it was great. I love it when the attorneys go back and forth in an intelligent way, right? Not the mess we saw in the ASAP Rocky trial. That was just a mess. But I do like the way that Alessi and Brennan, uh, you know, advocate for their different positions. I enjoy their advocacy. That's it. So we will reconvene on Monday. Okay, we'll start off this Monday thing with the Diddy stuff. We'll start off 7 a.m. Oh, Real thing said she figured I'd love it. I enjoyed it. I absolutely, because I was enjoying it a little too much when it started out, but I was like, no, let me stop watching because I need to talk to my co-counsels in real time. A good night, real thing. Yeah, so let's reconvene on Monday. Good night, Benji. Shout out to the replay crew. Shout out to everybody who was here, okay? So let's reconvene on Monday. We start with the Diddy stuff. Diddy stuff is a little difficult to stomach, but I am getting into the defense more. I'm getting into the defense more, and that's just because initially I wondered how the defense was going to cross-examine Cassie, but considering that um, these folks were in some sort of relationship for an extended time, what I'm hearing every once in a while, there are glimmers of hope there. There are glimmers of hope. Um, in any event, all right, last time I'm saying this. We're reconvening on Monday. We start at 7 a.m. We're going to end at 8 p.m. Not 8 p.m. That's crazy. I have to go to work. 8 a.m. Eastern Time. And then we'll stick to our regular schedule with Karen Reed, which is 7. No, it's not 7. It's 8:30 p.m. on Tuesday. Thursday, it's going to be a little shifty. Thursday, I might come up here much later. That's because my daughter has a concert, but we'll work it out. We'll work it out. All right, Benji. Real thing. I hope you guys have a great weekend. I cannot wait for the weekend because I'll be working. Yay. All right, you guys. Bye.